I call the meeting to order. This is the second meeting of the Bills Committee on Private Columbaria Bill. The first item is to follow up on matters of arising of the last meeting, and there are different views. There were different views expressed last time in relation to whether to have a public hearing. And in the end, 19 members think that we only need to invite members of the public to give us submissions. And 8 members think that members of the public should be invited to make to give written submissions and to make verbal submissions, and no members suggested to invite members of the public to give verbal submission. In light of this, we decide not to conduct public hearings. However, we will invite stakeholders to give written submission to us for our reference. Item 2, meeting with the administration. Please invite the administration to join us. Today and in the past couple of days, we have received some submission from some groups. You have received 2, and there are also another 2 tabled. I remember last time Mr. Lo Wei Kwok asked if the administration has taken on board some proposals for CSAs. The administration said that they have. Then they have given us a paper. It's a very long title. It's key issues of concern discussed at the Bills Committee formed under the 5th LegCo with committee stage amendments, CSAs incorporated into the reintroduced bill. Is CB bracket 2449/16 to 17 bracket 01. I believe that you all have this paper with you, and we have with us Mr. Daniel Chang, Deputy Secretary for Food and Health, Ms. Diane Wong, Principal Assistant Secretary for Food and Health, Mr. Peter C., Senior Government Counsel of the Department of Justice, and a number of other government officials. So, in relation to policy area, any members who would like to talk about comments in relation to this on a macro level? Otherwise, I will ask the administration to present this paper with a very long title, and then we'll ask questions. Any questions in relation to policy areas on a macro level? Otherwise, I'll ask the officials to take us through the paper. Or you can tell us what you have incorporated. PAS. In the last discussion, Mr. Lo Wei Kwok asked us to succinctly set out areas of concern discussed in the last LegCo term. We have tabularized it. We have set out the issues of concern, the CSAs, and the provisions in this bill, setting out the page number. There are about 20 issues of concern, and I will go through them very quickly. If you have any questions, do ask me. First, in relation to synthetic materials. After we have introduced a bill, members said that there are some cases that have made use of the loophole. So we would like to plug these loopholes and expand the scope of the bill to cover synthetic materials as well. Of course, we understand that from a societal point of view, course, they promote sustainability and environmentally friendly ways in burial. And we propose that if certain conditions are met, these conditions are quite strict, then exemptions could be sought. You will be able to find the relevant provisions in the bill reflecting this. 2 is in relation to exhibition venues, that is, in relation to temporary display of ashes. Some religious groups might ask overseas or on the mainland to display Buddha's relics. We have proposed CSAs to state that if it is a temporary display of ashes, as long as the number of conditions, say short length, 14 days, or temporary in nature, then it will be excluded from relevant provisions. And there are some members who have proposed that, well, at home you can inter human ashes. However, as we don't want to affect this, so we provide that if there are no less than 5 containers, then it will be excluded. But some members said that for big families, 5 containers might not be enough. So we have increased the number from 5 to 10 containers. Next is in relation to deeds of mutual covenant. So we're talking about columbaria in multi-story buildings. In these buildings, sometimes the DMC might prohibit columbarium use. So should this be considered by the licensing board? Well, we have taken into account the practice of the licensing board of the HAB, and we have incorporated the CSAs to require an applicant for the issue of a license submit a written legal advice of a legal practitioner to the licensing board, to confirm that there is no express restrictive covenant in the DMC, say for example prohibition of any use of the premises as a columbarium.
Or for example, the premises is not allowed for commercial use, or that only private residential use of the premises is permitted. Under such circumstances, if there is a confirmation that there is no express restrictive covenant, then the licensing board shall be able to proceed with the application. Number 5, we had the cut-off date. That is 8 a.m. on the 18th of June 2014. That is the cut-off time. Operators, customers were all required to observe this cut-off time, and there is a pre-cut-off time, so niches, meaning the agreement signed before that time, and there were some views expressed in relation to that. And having considered the views, we have incorporated CSAs. For niches sold before the cut-off time, before passage of the bill, if ashes were interred, then it will not render the applicant ineligible. And if he applies for an exemption, then he can inter the ashes subsequently, so as to minimize the impact on consumers. Point number 6 relates to religious ash pagodas. We've heard views from the religious sector and members of the public, because religious ash pagodas exist not only in Hong Kong but in the mainland and overseas. And after introducing the bill, ashes of deceased religious practitioners would no longer be able to be interred in these pagodas. Some consider this too rigid, and we have therefore incorporated CSAs. For ashes of deceased religious practitioners in Chinese temples, without any fees charged, the ashes can be interred. And if before the bill was passed, if there were already religious ash pagodas, and if the conditions are met, for example, no fees charged, then he can an application can be made for an exemption. And then the Secretary for Home Affairs will go through some procedures. For example, there will be the publication of a notice stating that it is a religious ash pagoda, and there would also be additional conditions. If these conditions are met, then the ashes of deceased religious practitioners can be interred in the religious ash pagodas. Point number 7. Well, the neighborhood may be concerned about the compliance records of the Columbaria, and the licensing board should have regard to the past records of non-compliance with the requirements for planning, land and building, and we have incorporated CSAs to expressly provide that the applicant or the board can give consideration to the compliance record of all the requirements in Schedule 2. Point number 8 is about the notification scheme. There were views that the notification scheme might be too stringent. Perhaps for some reason, for some reasons, some cases may not have joined the notification scheme, but they should be given a chance. So we have incorporated CSAs for the licensing board to consider cases outside the notification scheme, as long as evidence is provided to the licensing board. It can still be considered. Point number 9. Regarding exemption arrangements, an application will be made to the Lands Department and for consideration of waiver of land premium, and some members suggested that there should be provisions in this regard, because Columbarium operators may impose fees or charges on customers after they are granted land premium waiver, and therefore we have incorporated CSAs for the licensing board to impose conditions on a specified instrument in respect of a pre-cutoff columbarium, restricting the imposition of additional fees or charges outside the agreement. Point number 10. We require applicants the following. If there are material changes in the information provided, then the applicant should notify the licensing board. And the holder of a specified instrument will be required to notify the licensing board of any material change of information, and that's included in the CSA. Point number 11. Some members suggested that an applicant may be a partner in a partnership or a body corporate or a natural person. Say if it's a body corporate or an NGO, then there must be a responsible person. So let's say if in a case of a partner in a partnership, in order to have in order to clarify the liability, authorization from partnership or body corporate should be required. So we have incorporated CSAs to set out clearly the authorization requirement for a partner in a partnership. The application has to be signed by the partner who is authorized to do so, and if the applicant is a body corporate, the application has to be signed by the person in charge who is authorized in writing to do so. Point number 12. In respect of inspection power, some members suggested that there might be too much power given. The fact that there is power to remove and impound, and we have taken on board the views and incorporated CSAs to remove the power to delete the power to remove and impound so far as inspection is concerned. Point number 13. Consumers may be concerned because after buying a niche, they will be holding the interment right for a long time, and there is a concern whether a further transfer would be made by the transferee, and we have incorporated CSAs in this regard, and that is to say, the transferee is liable for all the obligations in relation to the agreement for sale entered before the transfer. So once ashes are entered, then a transferee must fulfill its obligation. Point 14. Authorized Representative. When a Columbarium is required to handle the ashes, then it can be the authorized representative and make claims in the capacity as an agent. And some members ask whether there would be a conflict of interest. We have incorporated CSAs, therefore, to amend the definition of authorized representative to stipulate that the Columbarium operator or the agents cannot be an authorized representative. Point number 15. Some members and the legal advisor expressed concern on the following matter. If the agreement is not enforceable, then the agreement can be cancelled at any time. So it might be giving the purchaser too much power. Say if no payment has been made, then it can be cancelled. And we have discussed with the legal advisor. Now say an operator may claim that he is licensed, but at the time of sale he may still not be issued a license. And in fact, within a reasonable period of time, we should allow the obligations to be fulfilled, and therefore we have incorporated CSAs to provide that if the obligations are not fulfilled within a period of time, then the agreement can be cancelled. In some other circumstances involving less serious issues, then the agreement can be cancelled within 6 months after the date of the agreement. Point 16. Again, some members and the legal advisor suggested that the bill should set out the particulars required to be covered in an agreement for sale of an interment right, and we have incorporated CSAs to this effect. Number 17. Some members of the public suggested that if the purchaser, who is the dedicated person, dies, and if the purchaser's relative or friend wishes to enforce the agreement on his behalf, then according to experience, because that relative or friend is not privy to the contract, he may not be able to enforce the contract. And we have therefore incorporated CSAs to require that the purchaser can authorize another person to enforce the agreement. Say if the dedicated person dies, then another person can be authorized to enforce the agreement. Point 18 relates to ash disposal by a third party. You may recall that apart from the operator who is responsible for ash disposal, the mortgagee or an owner may take possession of the premises, and as a result, he may have the obligation to carry out the ash disposal procedures. And yet we need to make a distinction. Some third parties may be in the know, say there may be land registry record, and the third party therefore should understand his obligations, whereas in other circumstances a third party, being a mortgagee, may be an innocent party. And in such cases, the Director of Food and Environmental Hygiene may be invited to carry out ash disposal. But of course, the FEHD officer must be able to gain entry into the premises for the ash disposal procedure, so as to alleviate the burden on the innocent third party. Point 19. The operator will be required to provide information for the person in possession to carry out the prescribed disposal procedures, and we have incorporated CSAs to make it clear what procedures to follow. Point 20. Some members suggested that there is a lack of clarity if only the word court is used, and we need to make a distinction of the level of court expected to deal with the situations, and we have therefore incorporated CSAs to that effect. In relation to an occupation order, etc., a magistrate may deal with that, whereas for handling claims of return of ashes, it will be done in the district court.
And in relation to occupation order, some members mentioned that when an application for an occupation order is made, it may involve entry into the premises. It should only cover the reasonable areas that is used for the storage of ashes. So sometimes one doesn't have to enter the entirety of the premises, only part of it will do. So these are all the issues of concern raised by members, and we have tried to alleviate your concern by introducing CSAs. Thank you. I ask members, any questions? Any questions? If not, yes, Mr. Ray Chan. Thank you. I would like to ask questions related to this paper. Point 3. Some members have raised this issue. If it's raised from 5 containers to 10 containers for a large family, what if it's a subdivided flat? If it's subdivided into 10 flats, as long as someone said that, well, it's a family in there, a large family in there, that means there will, say, one premises is subdivided into 10, each containing 10 containers. That means there will be 100 containers in there. And I want to talk about after the cutoff date if the ashes is not interred? What is the treatment? Perhaps there are some unsold niches. Say, for example, half of the niches have been sold, and they told you that they've all been sold, and they found ways to transfer the niches in private. How do you deal with that? Who is going to answer this? Ms. Wong, Deputy Secretary. I will answer at the other way around. Before cut-off time, and when the niches have been sold, after the bill was introduced, there was quite a very long time when the FEHD made use of an administrative scheme to check Columbarium operating at that time. And the majority of those we've contacted allow us entry. And there was a detailed inspection made with photos taken, information obtained, say for example how many niches there were, how many of them have been sold, and their locations. And we've already said in the bill that the licensing board, when dealing with the application of a specified instrument, exemption or renewal, they will refer to all the information available. So we are quite confident that this won't happen. That is, say for example, at the cutoff day, 500 out of 1,000 have been sold, and now when in actual fact 700 or so have been sold. We don't think that will happen. And in relation to large families, last time some members have asked a similar question and answers have been given. We use residents of families as a unit. So they have to prove that someone actually resides in the premises. So it won't be a situation, there won't be a situation when a premises, say, is 100 square feet and 10 rooms have been made from that by dividing the premises. I don't think that will happen. And I think in the end it's a matter of a balancing exercise. For a large family, whether it's 5 or 10, well, some members said that there are indeed large families and there is such a need. And if the provision is calcified, then it will be too restrictive. Well, given the current, the current situation, there is no restriction, so you can easily put 20 in them. So, what about a Columbarium? Which have asked a company to sell all their niches, but they told you they have not all been sold. And since for some of them no interment has been done, can they transfer the niche in themselves in private? And I think you need to look at it from the perspective of what happened, so that you understand it more easily. Say, for example, well, when the bill comes into effect, and if they have not been sold, then you can't inter ashes. But if it's an exempted one and is sold, then interment is allowed only after the specified instrument has been obtained. And when there was the administrative scheme and the cutoff day, they all happened before the CSA. I'm sure that they won't be so clever as to knew the CSA would be coming. At the time when the FEHD went to conduct inspections, they would do as much as they could, but of course they couldn't cover everything or all the contracts. Under the bill, if it's exempted, then no sale and purchase is allowed. The spirit of an exemption is to freeze it. I'll defer to the Assistant Director of the FEHD to explain. Mr. Chiu. Thank you. Just now, the DS has touched on this. If an application is made for a specified instrument, and if the applicant said that prior to the cutoff date the niches have been sold and that they would like to proceed with interment before the passage of the bill, or after they have obtained the instrument they would like to proceed with interment, then they have to supply us with relevant documents. So at the time of a purchase, there will be some contract or a sales record. So does it mean that during that time they're not allowed to sell or transfer the use of the niche? The spirit of the bill is that for future operators, so they can ask for exemption, that is those operating before the established before the 90s, or they can apply for a proper license. Exemption is itself a grandfathering arrangement, and if a proper license is applied for, then there won't be any special restriction. Let's hear from other members. Anyone else? Mr. Chen, would you like to ask more questions? That is, I would like to ask about number 9, fees, charges. Does it mean that when a fee or charges is agreed, then after the passage of the bill, one is prohibited from imposing additional charges under different names? Yes, the spirit is to deal with it in accordance with the contract. And at that time, the discussion of the Bills Committee was that when an operator applied for exemption or a license, the operator has incurred some expenses, and the operator would like to shift them onto customers. It's not the case that there can't be any changes in the fees or charges. It's just that we don't allow them to shift the cost or the expenses onto customers. Well, it actually means that the amount cannot exceed the amount stated in the contract. And they should not charge an amount that exceeds the one that has already been fixed under the exemption mechanism. So any flexibilities, any elbow room for them to charge more. Perhaps DS or PAS, you should explain that at the time of signing the contract, apart from buying the niche, do they have to pay for, say, management and utilities? Maybe you explain it in this way. Different contracts are different. It depends on the situation. We have looked at 2 dozen or so. Say, management fees may be imposed. And last time, members ask us to obtain more contracts for our reference. We will look at more contracts to see what more we can do. If there are no other questions, perhaps we can go into clause by clause, because we have had a lot of discussions in relation to the direction and the principles. Shall I ask the administration to proceed with the clause by clause? Yes. I'll ask the legal advisor to help us if he identifies some issues. Well, there are many different parts. I will go through the salient points so that I will be as succinct as possible. The first one is the short title and commencement. So on the date when it's gazetted, the bill comes into effect, save and except Section 3. Well, for Section 3, Part 4, is in relation to the application of specified instrument. And Part 5, the second division, is in relation to regulations, say register, requirements to notify the licensing board of any changes. These provisions are only required after the bill has come into effect. So when the bill has been passed, and 6 months later these provisions will come into effect. And the others are in relation to town planning, lands and buildings, and also the power to enforce the law. There are some exclusions. So they are they will come into effect 6 months after the passage of the bill.
As for Divisions 1, 2, 3 of Part 11, these are consequential amendments, and therefore they should come into effect on the expiry of 6 months. Schedules 2 has to do with some land and town and planning provisions. Schedule 3 relates to the instrument, and again these will come into operation on the expiry of 6 months. Clause 2, interpretation, sets out the definitions of different terms. Perhaps I won't go through each and every one of them. There is a long list. Let me ask if members have any comment on clause 1 and 2. No?
係好簡單嘅嘢，同埋好清楚嘅一啲資料嚟嘅啫。
I think these are really clear. Anything to ask? Legal advisor? No? We can move on to clause 3. Clause 3 relates to the meaning of sale of interment right, and it sets out in clause 3 what an interment or sale of interment right means. For example, in 3.1, bracket 1, sale includes an offer to sell the interment right or to make an agreement for the sale of interment right to another person. And for the purposes of this ordinance, the sale of an interment right in respect of a columbarium includes a disposition of the interment right to a person if the person directly or indirectly in connection with the disposition makes payments in one or more of the following manners. A. If the person pays a sum periodically during a period for which the interment right lasts, or B, pays a fixed sum by installment or otherwise, and C, makes payments in any other manner. So whether or not it is a one-off payment or it is payment by installments or hire purchase, these are all captured under this subsection. And then bracket 3, for the purposes of this ordinance, a sale of an interment right includes such a sale even before the columbarium is constructed. So that is to buy a pre-completed niche. And also such a sale even if no dedicated person is named. And 3, such a sale to a person for resale. 3b. A sale of an interment right in respect of a niche in the columbarium includes a sale of an interment right in respect of 1. A particular niche or a niche to be allocated in a columbarium. So it's either a particular niche, A101, let's say, or an unspecified niche. 2. A niche in existence or a niche to be constructed in the columbarium. So you can see that as far as the definition of the sale of interment right is concerned, it covers a wide scope. Any comment on the meaning of sale of interment right? Any question? If not, clause 4. Clause 4 relates to premises that is not captured in this ordinance. For example, the FEHD's public columbarium or private cemeteries columbarium. Because there may also be a columbarium in the private crematorium. In Cap 132, it refers to a columbarium in a private crematorium, because you may need to cool down the ashes before they're interred, and they would be temporarily placed in a private crematorium. Because in Cap 132 we have provisions regulating the undertakers of burial, and therefore they will not be captured in this ordinance. But I want to supplement that although the above mentions do not apply here, in Part 7, Schedule 5, they are still included. For example, in the future, if they cease operation, they will need to follow the procedures. Any question or comments on Clause 4 about exemption for undertakers of burials? You say that the interment is captured or is regulated under another piece of legislation. So any requirement as to how long the period means, 10 years? Well, there is no clear provision, but we do regularly review the situation, considering the supply of niches and considering whether we should impose additional conditions. I'd also like to ask about undertakers of burials regulation. When we, in previous meetings, some members asked about masonry and bone collectors who also offer temporary interment of ashes. I want to know whether there is a gray area here. Now, some of them have the undertakers of burials license, and if they have the license, they will be subject to the regulation. But if not, as we explained before, there will be administrative arrangements. Let's say after 10 years of burial, the bones may be exhumed and the ashes will be returned to the family. So it would only be temporarily placed with the undertaker. And the family members would go to the FEHD office to claim the ashes. So it may not be necessary for the ashes to be deposited there. So is there any time limit specified in the Undertakers of Burials regulation? Say 1 year, half a year before it is removed. Otherwise, it will be in fact a permanent interment. According to the regulation, the place of business of the license holder must be specified. So it's confined unless the places of business continue to increase. The license holder will need to observe this condition. For the keeping of ashes, it's just temporary keeping. And what Ms. Wong meant just now was that there is no clear provision as to how long the temporary period should be. But as I said just now, the principle is that it should be for temporary keeping. Any questions from members? Ms. Shen. Temporary keeping, so would the worshipping be allowed? Is it allowed, or is there a practice now? Mr. Chiu from FEHD. Thank you, member, for the question. Well, of course, we do not require the licensed undertaker of burial to prevent any kind of memorial service or ritual to be carried out by the family members. But in Hong Kong, for example, there are license holders allowing family members to worship either in their premises or even in the street in public, and it is undesirable because it generates an environmental hygiene problem. In recent years, we have been talking to the district council, and we have implemented measures and worked with other departments. And for example, in Hong Kong, the license holders have been cooperative, whilst our officers have also stepped up control, and I can say that the situation has improved. I think you must have an idea of the number of licenses and their places of business. I don't know whether you've given this information before to the Bills Committee. Another question is on whether fees and charges can be imposed by the undertakers of burials for, say, temporary keeping of ashes, cleaning, etc. Well, in fact, in Cap 132, there are provisions regulating them, and also for applications made after December 2008, these licensees are not allowed to keep ashes. So we only have 81 such licensees allowing temporary keeping of ashes as of now. And as mentioned by the Assistant Director, in Hong Kong, we do allow a spot where people can burn offerings instead of burning them in the public street, so as to minimize the impact, nuisance to the area. For prolonged period of keeping of ashes, it would also affect licensees in getting business. So I think they also have their own arrangements in this regard. Any questions from members? If not, then Clause 5. Clause 5 relates to the procedure of transforming ash into synthetic materials. You can see that towards the end of Clause 5, we have provided definitions for synthetic material and transformation work. Some preconditions have to be met. For example, the workplace is not situated within any Columbarium premises. We don't want anyone to plug this loophole by placing machinery there. And the keeping of ashes in the workplace must be transient and incidental to the carrying out of the transformation work. No interment right in respect of the workplace is sold. And no person may be allowed to pay worship or give ritual offerings in the workplace to any deceased person. Number 5. The person operating, keeping, managing, or in any other way having control of the workplace has kept a register of the delivery of ashes and synthetic materials to and from the workplace. And we've set out the particulars to be included in the register. If these preconditions are met, then they will be exempted from this provision. Any questions? If not, then clause 6 about transient exhibition of ashes in premises. If some conditions are met, then this ordinance is not applicable to the premises. For example, the exhibition should not be held for more than 14 days. The ashes are kept in, on, or at the premises only for the purpose of the exhibition. There should be no more than 10 containers of ashes, and each container must only contain the ashes of only one person, and no interment right in respect of the premises is sold. Any questions on clause 6? Clause 7. Ordinance not applicable to domestic keeping of ashes. As explained before, if ashes are kept in domestic premises and if there are no more than 10 containers of ashes, and if each container only contains the ashes of one person, then it is not applicable. And in subsection 2, you can refer to domestic premises, which means premises used solely or principally for residential purposes and constituting a separate household unit. Mr. Chan.
Might have digressed a little bit. What about Columbarium in a village house? So, if it's in a small house is for residential use of an indigenous villager, how would you deal with that? If it's residential, then it's only 10. But what if it is Columbarium that is located in a village house? If there are more than 10, then an application for a license is to be made, and they have to make applications to regularize it. So can a small house be used as a columbarium? There are some. But in theory, small houses are for residential use only. And I think they have to meet the land use requirements, and if they want to transact the village house, then they will have to obtain certain instruments. But at the moment, there are no laws regulating that. So what if it is a village type development? It's a 700 square feet village house. Should they make applications, and will it be approved? They can make an application to the Lands Department for regularization. For some, there are provisions saying that human ashes are not to be placed therein, and it depends on the provisions. They may have to sometimes make payment. So an application can be made, but whether an approval is given is down to the licensing conditions and also the Lands Department. Dr. K.K. Kwok. It said that for a village house there can be no more than 10, not small houses, domestic premises. What about domestic premises that have been subdivided? Dr. Kwok, we have already discussed this point and an answer has already been given by the administration. Perhaps Ms. Wong, you should give the answer again. Well, they have to prove that it is for residential purpose constituting a separate household unit. What about unit that is 120 square feet to place a bed that is good for an emperor? You know about such development. So in that flat, you can place 10 containers. And if there are, say for example, 64 such units on the same floor, that means 614 issues can be placed on the same floor. But this already been covered. Clause 7 is about the definition of domestic premises is quite clear. It means the premises used solely for residential purpose and constitute a separate household unit. So if, in your case, during the inspection, the department will think that it is not a household unit. So any restriction on the size, 120 feet is its own unit with kitchen and toilet, and it can place how many containers. And in the future, developers may come up with flats that is only 90 square feet with kitchen and a toilet. Then it can store 10 containers. I have already explained this. The original provision in the bill stated 5. And in response to discussions in the Bills Committee and members saying that there are some large families in Hong Kong, we had a discussion of how many was to be allowed. And in the end, we've decided 10. And currently, without the bill, there is no restriction whatsoever. So we have imposed a restriction through this bill. Mr. Leung Kwok Hong, I want to ask you, I was in the manpower panel. Well, I want to say that you explained that about families. You mean these urns have to be have to contain the ashes that is of a direct family members. Do you actually check that? Under the bill, it says in each domestic premises, no more than 10 containers are to be kept. I understand. But then there will be problems because you may ask someone, you may employ someone to just sit there with the urns. I thought that some families have grown, and so 5 is not enough and it has to be 10. So why don't you simply say that it has to be direct family members? And I think at that time the spirit was that was to give some flexibility. Some families are bigger, some are smaller. Some families do mind about having ashes at home, some others don't. We're only talking about a very small number, 10 at most. Well, in the last legislative term, the administration proposed 5. And in response to issues we've raised, they've increased it to 10. I am concerned about family members. Let's hear from the legal advisor. Thank you. In relation to Clause 7, in the last Bills Committee, there were some questions raised in relation to interment of ashes and turning human ashes into synthetic diamond. Well, now it says 10 containers, and if the synthetic diamond is not put in these containers, then they are not counted as one container. And there was nothing said about how many the ashes of how many people in one single container. The administration said that they would incorporate CSAs, and there would be a review to allay members' concern when they raised this issue, and members accepted that. The administration will conduct a review. They will come back to us, and they think that is in line with what members suggested in the last term, and the administration will undertake to conduct a review. Yes. To be honest, if they've been turned into synthetic diamond, then you won't be able to regulate it. Say, for example, is a string of prayer beads. There can be many of them, say 108. You won't be able to regulate that at all. Well, what I want to say is that the small house policy is to meet the needs for homes of indigenous villagers, so it's not for storage of niches or urns. And if an application can be made to turn village houses into columbaria, then it runs counter to the policy of anti-small houses. Yes. Well, no matter what shape or form these premises are, they have to meet all the licensing conditions. We don't want to be so rigid that in certain cases applications are not allowed. Of course, even if you make an application, you have to go through the Lands Department and the licensing board. If it is a domestic premises, they will consider whether is a village house or not, without considering other factors. That is the case. We have finished part 1. Now part 2, clause 8. Ms. Wong. This is in relation to the establishment of licensing board, which states the Chinese name and the English name. And please hold on. Your work plan. You said you will start with parts 3 and 4, or you want to go with the blue bill? Okay, we will follow the work plan, and in that case we will go to part 3, which is the regulatory regime. All the way to the end of part 4. Well, just now we have talked about provisions that will come into effect later. If you turn to part 3C 862, that is in relation to control on operation of Columbaria, is an important provision. It states the condition. It states as the restrictions on operation of a columbarium. Under clause 10, subclause 1, it says a person must not operate, keep, manage, or in any way have control of a columbaria otherwise than under a license. Subclause 2 states that subsection 1 does not prohibit a person from operating, keeping, managing, or in any way having control of a columbarium otherwise than under a license if the person does not sell any interment right in respect of the columbarium, or the person holds in respect of the columbarium an exemption or a temporary suspension of liability. Subclause 3 states that if a specified instrument is suspended, or if an authorization to sell interment right is suspended, and that specified instrument or authorization under a license, or in relation to that, the person who operates, keeps, manages, or in any way has control of the Columbarium does not then if that person meet all the terms and requirements imposed, then it's not a contravention of subsection 1. Say, for example, when some process in relation to the building is being undertaken, which is to meet certain conditions, we will not say that the person has contravened this provision. Any questions? Any question from the legal advisor? 11. We now move on to offences, because under clause 10 there is restriction. Well, it says in subclause 1 that if a person contravenes section subbracket 1, the person commits an offence. And under B it says that each person who is the owner, tenant, lessee, or person in charge commits an offence. And under subclause 2 it says that upon summary conviction, a person may be fined $2 million and an imprisonment for 3 years. And if it is on conviction on indictment, is a fine of $5 million and imprisonment for 7 years. So clause 3 states that if a person is charged with an offence under subsection 1, and if that person can establish that at the time of the alleged offence the person did not know and could not have reasonably known that the premises was a Columbarium, or the person believed on reasonable grounds that the person operated did so under a license or did not sell any interment right under the exemption or the temporary suspension of liability. That means, if there is a defense, then they will be protected. And under subclause 4, it says that if a person can establish a defense under subsection 3A or B, then the person, and if there is sufficient evidence to raise an issue to that alleged fact, or the contrary is not proved by the prosecution beyond reasonable doubt, then the person is charged.
Subsection 5 refers to the effect of subsection 1 subject to section 73(1). And 73(1) means that after taking over the premises, if notice is given to a director of FEH in 7 days, then one will not be inadvertently caught by the law. Mr. Chen, in clause 11(1)(b), if the person knows that the operator is unlicensed but patronizes the operator anyway, then will the person be the tenant, etc.? Well, we have the definition regarding the owner, and when it comes to the customer, we're talking about the interment right, or the right to use the premises, but the customer may not be in control of the premises. So here it does not refer to consumers. Mr. Holden Chow. Is the mic on? Well, on the issue of tenant and lessee, I want to know whether this would cause any misunderstanding, because the user is the consumer according to you, and it's not regarded as a tenant in this provision. So, say if A is the owner, and then A leases the premises to B, who is the tenant, and then the B then sells niches to C, the consumer. So, in other words, the consumer is not the tenant. Who would take the question, Mr. C? Now, referring to 11(1)(b). We're talking about the owner, tenant, lessee of the Columbarium premises. So we're talking about parties to the tenancy agreement of the Columbarium premises. Whereas for consumers, under the framework of the bill, what they have is the interment right. So it is not the same concept as the owner, tenant, or lessee mentioned in 11(1)(b). So a consumer is not the owner, tenant, or lessee referred to in 11(1)(b). Right. 11(1)(b), according to your explanation, the owner, tenant, or lessee in 11(1)(b) does not mean the consumer. No other questions? 12. Clause 12. Part 4 relates to instruments required for operating Columbaria. Clause 12 is interpretation clause. We provide definitions for some terminology in this clause. First is Ash Interment layout. That is, in relation to Columbarium, the layout means the location, serial numbering of niches, or if a license is applied for or is issued in respect of the Columbarium, then it is any area in the Columbarium in which ashes may be interred or otherwise than in niches. And C, if the Columbarium is a Columbarium of a Chinese temple as referred to in section 55, then an exemption will be applied for, and then the location of the religious ash pagoda will be specified, and this is what is meant by ash interment layout. The second one is ash interment capacity. For a license applied for is issued, it means the maximum number of containers of ashes that may be interred in each niche in the Columbarium, and the total maximum number of sets of ashes that may be interred in the niches. B, the total maximum number of sets of ashes that may be interred otherwise than in niches in any area in the Columbarium. And C, the total maximum number of sets of ashes that may be interred in the Columbarium. The third definition refers to the ash interment quantity. A, the number of containers of ashes interred in each niche in the Columbarium, and the total number of sets of ashes interred in the niches. And B, the number of sets of ashes that are interred otherwise than in niches in any area in the Columbarium, say for example temporary keeping, and C, the total number of sets of ashes that are interred in the Columbarium. No questions? Clause 13. License, exemption, and temporary suspension of liability. The licensing board may, on application, and subject to any conditions that the licensing board thinks fit to impose, in addition to the conditions mentioned, issue or renew a license, or issue or renew an exemption, or issue or extend the temporary suspension of liability in respect of Columbarium. Ms. Tanya Chan. Sorry, I'd like to go back to clause 12. On ash interment quantity, I have a question for the legal advisor. we don't often see something like this in, say, A. The number of container of ashes interred in each niche in the columbarium and the total number of sets. I mean, in Chinese, it literally means how many containers of ashes interred and how many sets of ashes interred. We don't often see that in respect of the terminology. And I can also ask Mr. Holden Chow's opinion. Maybe because my specialty is in criminal legislation, I don't think I often see that. Well, legal advisor, I think it is necessary to draft it that way because the number of containers of ashes interred is the subject of the government's regulation. Well, you can see that it's very detailed. The number of containers of ashes in each niche. So it has a lot of details here. Well, I'm just concerned about the text. If the legal advisor's opinion is that it is all right, then I think it is acceptable. Any questions on clause 13, clause 14? Clause 14 relates to time limit for application for a specified instrument. So clause 1 relates to the arrangement in connection with pre-cut-off columbaria, whereas for other columbaria, an application for the issue of a license may be made to the licensing board at any time after the expiry of 6 months beginning on the enactment date. But of course, before the license is issued by the licensing board, no Ash interment may be allowed. Subclause 2 relates to pre-cut-off columbaria. After the passage of the bill, a pre-cut-off columbarium must apply to the licensing board for the issue of a specified instrument after the expiry of 6 months, but before the expiry of 9 months, beginning on the enactment date. Subclause 3, we would like to give ample time for the licensing board to process the applications. So an application for the renewal of a license or exemption must be made to the board not later than 18 months before the expiry of the validity period. Subclauses 4 and 5 relates to the temporary suspension of liability. The validity period should not be longer than 3 years. And yet in subclause 4, let's say if the validity period is one of 3 years, then 12 months before the expiry of the validity period, the operator should apply for an extension with the licensing board. But if the period is shorter, say in subclause 5, if the temporary suspension liability's validity period does not exceed 12 months, then it would be meaningless to require an application to be made 12 months in advance. So the operator should make this application for extension of temporary suspension of liability not later than the date specified. So despite subsections 2 to 5, if the application is made out of time, then the applicant should have a reasonable excuse for making this out-of-time application, and the licensing board can consider this out-of-time application if it is just and equitable to do so. Any questions?
15條。
係，咁第15條呢，就係講如果
Clause 15. Validity period of specified instrument. Subclause 1. The licensing board may, in its discretion, determine the term for which the specified instrument is issued, renewed, or extended. This is the definition of validity period. The validity period of a license must not exceed the shorter of the following. First, if the Columbarium premises are held directly from the government under a lease, the remainder of the term of the lease. Let's say if the Columbarium premises are occupied under a tenancy, then it refers to the remainder of the term of the tenancy. And there is also this 10-year requirement. So it's the shorter of the following. If it's shorter than 10 years, then it is A. And if the tenancy of the lease is more than 10 years, then the shorter period would be 10 years. Next, the exemption. If the Columbarium premises are held directly from the government under a lease, then it is the remainder of the term of the lease. If it's occupied under a tenancy, it is the remainder of the term of the tenancy. So there is no 10-year limitation here. Subclause 4, temporary suspension of liability. The validity period must not exceed 3 years. Subclause 5, subject to subsections 2b and 4, where the Columbarium premises are occupied under a short-term tenancy granted by the government, the validity period of a specified instrument issued, renewed, or extended in respect of the premises may be concurrent with the period for which the short-term tenancy lasts. Subclause 6. A specified instrument in respect of which an application for renewal or extension is made, time may be needed for the licensing board to process the application, and in the interim, the instrument may be expired. And we do not want to compel the removal of ashes once the instrument is expired. So we stipulate here that it should expire until it won't expire until the licensing board has a determination. So it says here that it remains in effect until the determination of the application, unless the application is withdrawn, the specified instrument is revoked, and for a license the term expires, or for an exemption the term expires. So unless we have these circumstances, the specified instrument's validity period will remain in effect until the licensing board has a determination. And subclause 7, a license may be subject to review within its validity period, so that the board can see whether there has been any change in circumstances.
否則呢個暫免法律就
And 8 states that, well, unless it's an extraordinary circumstance, the extension of temporary suspension cannot be extended for more than one time. How come that the license says there is a 10 years length, but in some cases there is no such mention about 10 years. First, I would like to talk about an exemption. Exemption deals with those with a long history, that is, those established prior to 1990s, and with the exemption they cannot sell new niches. That is a grandfathering arrangement. So there is no need to impose a validity period on it, because it's different from a license. As for license, once it's obtained, they can sell new niches. So in the discussion of the last Bills Committee, some members said that, well, for a columbarium, it's long-term, 10 years is a very short time. On the other hand, there are some members who are of the view that this licensing regime is something new. There should be a validity period because it gives us a chance to review it. That's the background. Do you understand? Yes. Ms. Tanya Chan. Well, I want to ask something. The licensing board, the composition, anything about the composition of the licensing board? How frequently they will convene a meeting? What if their terms is going to expire, but they don't want to clear the ashes? Can they drag their feet? So how often will meetings be called? I want to know about how the licensing board works. In Schedule 1, you will find the composition of the licensing board. We're not there yet. We'll follow it up. Perhaps let's hear from the DS. Just some general information. Under Schedule 1, it's going to be no more than 7, and they will be appointed by the Chief Executive. And the licensing board will formulate guidelines in relation to frequency of meetings. At the beginning, I can assure you that it will be quite frequent. So then we have the 6+3. After 6 months after the passage of the bill, there will be application, and I think that for the first 9 months, almost all the applications would have been made. Who is going to be the Secretariat? The FEHD. Perhaps I will wait. I know it is a statutory body. Sometimes, I remember that they should appear earlier on in the Blue Bill instead of the back. Say, Town Planning Board. I see Section 8 and Section 101. It's like, is it similar to Schedule 1? Never mind, I'll ask questions when we get to Schedule 1. Legal Advisor. I ask members to pay attention to Clause 15, Subclause 6. And it says that in relation to application for renewal or extension of specified instrument, when an application was made and before a decision was made, if the specified instrument expired, it says that it will continue to be valid. However, there are 4 exceptions. So C and D. It says in relation to license or exemption, if the tenancy has expired, then the instrument will expire at the same time, and it will not be extended. And the second point is that the extension is until a decision is made by the licensing board. So if there are subsequent appeals, by then the instrument has already expired and the ashes will have to be cleared. Mr. Ray Chan. Bracket 4. The validity period of a temporary suspension of liability must not exceed 3 years. Bracket 8. It cannot be extended more than once. And it says the maximum period is 6 years. Why is it such a long period? If you said unless there is exceptional circumstances, then it should not be extended. So if there are exceptional circumstances, the board may extend it. Well, this is 3+3 has been discussed for a very long time. I think it is to build in flexibility. It's not the case that there will definitely be 3 years or definitely be a renewal, so 3+3. I know there is already flexibility because it says unless exceptional circumstances exist. So it can be renewed and extended and extended. So if it is within 3+3 years, the application for regularization has to be completed. Otherwise, you allow them to operate forever. I think you've done his job for him. Ms. Tanya Chen, you talk about the licensing board, and in part 2, 8, 9, 8 and 9 is covered. However, we have skipped that because we want to follow the administration's work plan, but we will go back to it. Yes. Well, there is also the appeals board. Any questions on 15? 16 now. This is about law enforcement action initiated before an application is made for a specified instrument, and in this case an application is not allowed. If you refer to bracket 2, and in relation to the operation of a columbarium, if it contravenes cap 131 section 20 bracket 7 or 21 bracket 1, that is in relation to an unauthorized development, legal proceedings at that time have already been initiated. And under cap 131 section 20 1 bracket 1 or 2, a notice has already been served. So the licensing board cannot give an approval. And bracket 3 is about safety. That is, prior to the issuance of a specified instrument, if there is any building or building works that is contravention of cap 123 section 14 bracket 1, and in relation to these building or building works, an order has been issued under section 24 bracket 1, which is served and is valid and not withdrawn, then the licensing board may not grant an application. Any questions? If not, we will go to 17. Yes. This will take us to Division 2 in relation to eligibility criteria of various specified instruments. Subdivision 1 is, Clause 17 is about license. Now, whether it is Columbarium before or after the cutoff time. And I will elaborate modifications in Clause 18. Well, subclause 1 under Clause 17 says that a person will have to satisfy the licensing board that the columbarium complies with the following, that is, those related to land, planning and building. When we go to Schedule 2, I will elaborate. B. The person has to satisfy the licensing board that the premises is obtained directly from the government under a lease. And subclause 2 states that the application will have to first submit a management plan through the which is approved by the licensing board. Bracket 3 is in relation to the DMC. if there is a DMC in force, then the applicant will have to, under Section 22(3), produce a legal advice. Otherwise, the licensing board may refuse the application. Any questions? And I think this will deal with what Mr. Ray Chan has mentioned, that is small houses, because they may not meet land-related requirements. Legal advisor, brackets 17, bracket 1, bracket B. It says that the applicant has to prove that the Columbarium premises is obtained directly from the government under a lease, and in successful cases of adverse possession, say for example there is a court order, the applicant does not meet the stipulations under 17(1)(b). Mr. Houghton Chow, I want to clarify. We were talking about provisions governing tenants, owner, lessees through a valid contract to lease the premises and operate it as a columbarium. This will be covered. But just now you mentioned about adverse possession. The provision does not regulate it, or am I wrong? It means that an application will not be granted under 17(1)(b). And if a license cannot be obtained, it means it is a contravention. So if someone started off with adverse possession, that person cannot apply for a license. No, the application will not be granted. Perhaps let's hear from the DS. There are provisions, and we will get there. Some columbaria might be operating for a number of years. Allowing them to make an application does not mean that they can adversely possess the site. And I think it's along that line of thinking.
OK， 咁即係如果話好似你剛才頭先秘書。
So in other words, like the Deputy Secretary said, if many years ago, through adverse possession, some operators, an operator operates on a piece of land, a columbarium, the license would not be granted to that operator. What if it's the other way around? Well, if an operator operates a columbarium on a site through adverse possession with ashes interred already, then if the license is not granted, then that means you need to go through the ash disposal procedures. Yes. Well, actually, there are two ways to deal with these columbaria. First is to grant exemption. Second is to apply for a license. In the case of an exemption, these columbaria may have existed for a long time, but we don't wish to encourage operators to run a columbarium through adverse possession. So, in other words, in the end of the day, the operator still may not be able to get an exemption because you do not want to encourage adverse possession. That's the message that I get. In fact, we have 130 odd columbaria, and we basically checked the information. We haven't identified any case of adverse possession, as it doesn't really exist in reality at the moment. I don't think we need to add to this bill. Clause 18. Modifications of Section 17 for pre-cutoff columbarium. As mentioned just now, Clause 17 basically applies, save and except a historical issue. We need to take a more pragmatic approach. Under these two circumstances specified, we allow some flexibility. Bracket 1. In respect of a pre-cutoff columbarium, information relating to the Ash Interment layout, Ash Interment capacity, etc. will have to be provided to the licensing board to the satisfaction of the licensing board. Bracket 2. Some structural requirements. Now, if the requirements are not met, and if there is non-compliant structure certifiable for a pre-cutoff or columbarium, and that the operator has followed the relevant requirements in the law, for example, engaging a qualified person to certify the works, and if these conditions are met, the licensing board may decide not to refuse the application, only because the applicant fails to comply with the building requirements. Bracket 3, regarding the period. Now, if the operator, if the columbarium is not in accordance with Clause 17, the licensing board may still grant the application. If the applicant can prove that he has the right to continue to use the columbarium premises for at least 5 years. Any other question? Clause 18, Mr. Ray Chan. Chairman, you mentioned 17(1)(a), which could address my concern. But then we have the modification in Clause 18, which means that columbarium operating in an indigenous house can still exist. When we talk about modifications, we do not mean that after the bill is passed, a new operator can make use of this modification. We're talking about pre-cutoff columbarium. If the pre-cutoff columbarium operator applies for a license, then he can rely on Clause 18. So it means that the license can be transferred because there should not be any change to the layout and other points. Chairman, if I may, because in the consultation process, we have one key element, and that is we want to minimize the impact on ashes already interred in existing columbaria. And that is why we have different arrangements for pre-cutoff columbarium and those after the cutoff date. Of course, the Lands Department would look at the situation, and the licensing board would do the same. It doesn't mean that the modifications clause would apply to all columbaria. So at the end of the day, it depends on whether the licensing board is satisfied. Yes, it is the gatekeeper. Any other questions on Clause 18? If not, then Clause 19. Clause 19 is the eligibility for exemption for pre-cutoff columbarium. So Clause 1 sets out in detail the eligibility criteria, Ash Interment layout, quantity, whether it is necessary for the operation, and ancillary facilities. That's in A to C, and D, E, F. These three subclauses are important. That the columbarium commenced operation before the 1st of January 1990. And in subclause 3, there is a definition. For the purpose of Subsection 1D, the operation of a columbarium commenced on the earlier of the following times: A. The earliest time when a set of ashes was interred in any niche in the columbarium, or B. The earliest time when an interment right in respect of any niche in the columbarium was sold. And then E. That no interment right in respect of the columbarium has been sold since the cutoff time. And F. The columbarium complies with the land-related requirements. And then G. Either the columbarium complies with the building-related requirements, or, if that cannot be done, if the non-compliant structures are structures certifiable for a pre-cutoff columbarium, and that professionals have been engaged for the purpose of certification, and the relevant works have been carried out, then it can be regarded as an eligible pre-cutoff columbarium. Then the H1. Either the applicant holds the columbarium premises directly from the government under a lease, or 2. The licensing board will have to be satisfied that the applicant has the right to continue to use the columbarium premises for at least 5 years. Subclause 2. If a niche is was sold beyond the cutoff time and before passage of the bill, religious practitioners' ashes were interred in a religious ash pagoda without any fees charged, then the application may still be approved. And that's in 2A1. If the increase in the ash interment quantity since the cutoff time is limited to ashes interred before the enactment date, and 2. If the interment right in respect of those ashes was sold before the cutoff time, then the applicant would not become ineligible. B1. The increase in the ash interment quantity since the cutoff time is limited to ashes interred in a religious ash pagoda, and no fees, charges, or other sums were paid or are payable for the interment of the ashes. Under such circumstances, the applicant would not be rendered ineligible. Any questions on Clause 19? I think if there are no other questions, we should stop here because Clause 20 is quite long. I don't think we have time to complete that. Members, I think I can wrap up the agenda item here. Item 3, any other business? Nothing under AOB. The next meeting is scheduled for the 13th of January 2017, 10:45, Wednesday in room 2A. Thank you. Merry Christmas and Happy New Year. Thank you.